This is the LWA Contract Conditions Audio Outline. A condition is not a promise. A condition is a promise modifier. The distinction between a promise and a condition is important. The failure of a promise gives rise to a breach, whereas the failure of a condition relieves a party of the obligation to perform. Conditions timing. Conditions can be classified by timing. There's condition precedent, there are conditions concurrent, and there are conditions subsequent. Condition precedent. Condition must occur before performance is due. When the condition occurs, performance is due. Conditions concurrent. Conditions to occur at the same time. If one condition has occurred, performance of the other is due. Condition subsequent. Condition cuts off an already existing duty. When the condition occurs, duty to perform is excused. Other ways to classify conditions. Conditions are also classified based on content. There are express conditions, implied conditions, constructive conditions. Express conditions. These are conditions that are expressed in the contract. Implied conditions. These conditions are inferred from evidence of the party's intention, also called implied in fact conditions. Constructive conditions. Constructive conditions are conditions read into a contract by the court without regard to the party's intention in order to ensure that the parties receive what they bargained for, also called implied in law conditions. Excuse of conditions. A duty of performance becomes absolute when conditions are either performed or excused. Conditions may be excused by failure to cooperate, actual breach, anticipatory repudiation, prospective inability or unwillingness to perform, election waiver or estoppel waiver, impossibility, impracticability, or frustration of performance. Excuse of condition, failure to cooperate. A party who wrongfully prevents a condition from occurring will no longer be given the benefit of it. Excuse of condition, actual breach. An actual material breach by one party excuses the other's duty of counter-performance. Note, a minor breach might suspend the duty but will not excuse it. Excuse of condition, anticipatory repudiation. Anticipatory repudiation must be unequivocal, not just an expression of doubt. It applies only if there are executory duties on both sides of the contract. Anticipatory repudiation gives the non-repudiating party four alternatives. 1. Treat the contract as totally repudiated and sue immediately. 2. Suspend their own performance and wait until performance is due to sue. 3. Treat the repudiation as an offer to rescind and treat the contract as discharged. Or 4. Ignore the repudiation and urge performance. Repudiation may be retracted until the non-repudiating party has accepted the repudiation or detrimentally relied on it. Excuse of condition, prospective inability or unwillingness to perform. A party might have reasonable grounds to believe the other party will be unable or unwilling to perform when performance is due. Prospective inability to perform merely raises doubts about performance. It does not meet the unequivocal requirement of anticipatory repudiation. Conduct is judged by a reasonable person standard. Effect of prospective failure to perform. The innocent party may suspend her own performance until she receives adequate assurances of performance. If the assurances are not forthcoming, she may treat the failure as a repudiation. Retraction is possible, but will be ineffective if the other party has changed her position in reliance of the prospective failure. Excuse of condition by waiver. Estoppel waiver. Estoppel waiver is when a party may waive a condition by indicating that they will not insist on it. However, such a retraction may be retracted at any time unless the other party relies on the waiver and changes her position to the detriment. Upon such detrimental reliance, the waiving party is estopped from asserting the condition. Excuse of condition by waiver. Election waiver. Election waiver. If a condition is broken, the party who was to have its benefit may either terminate their liability or continue under the contract. If they choose the latter, they are deemed to have waived the condition. Excuse of condition, impossibility. A condition may be excused by impossibility. This is measured by an objective standard, meaning nobody could have performed the condition. Impossibility may arise after the contract is entered into. Impossibility examples: 1. Death or physical incapacity of a party necessary to effectuate the contract. 2. Subsequently enacted law rendering the subject matter illegal. And 3. The subsequent destruction of the contract's subject matter or means of performance. Exam tip: impossibility. A condition is not excused by death or incapacity of the person who was to perform the services if the services are of a kind that can be delegated, i.e., not unique. Excuse of condition, impracticability. Impracticability is measured by a subjective standard. It requires that a party encounter extreme and unreasonable difficulty or expense that was not anticipated. A mere change in the difficulty or expense due to normal risks that could have been anticipated, i.e., increase in price of raw materials, will not warrant excuse of condition or discharge of performance. Excuse of condition, frustration of performance. A condition may be excused by frustration of performance. This requires 1. A supervening event. 2. That was not reasonably foreseeable at the time of entering into the contract. 3. Which completely or almost completely destroys the purpose of the contract. And 4. The purpose was understood by both parties. This ends the LWA Contract Conditions audio outline.